Oh, how you doing today?
Hello.
This is isn't this a judge?
Yes.
The chief
it's
judge.
The chief.
Oh, chief judge. I don't know if we met
Yeah,
before.
when
I don't believe we have.
All right.
700 is ready with his 95.
Here, let me, I'm going to share my contact info just so that you have it.
All right. All right. And then do we want to bring Hugh here as well?
Who?
Oh, Hugh is the DA.
Oh, we
Oh.
can. Oh, I'd
Sure.
have to go downstairs and
If
grab
he
him.
was around.
I don't think so. It doesn't look like he's answering. Oh, which is fine. Let me see. I'm going to send him a little message in case he does end up popping up.
So I briefly explained what this is about.
Yep. So, all right. So, yeah, so to give you my perspective, my previous precinct, it had limitations on a variety of it had a lot of restrictions on a lot of things. So, for example, if a weapon was seized as a part of a arrest or was a part of arrest, that unless charges were made then and there, that weapon would be considered using that weapon for further evidence would be considered fruit of the poisonous tree. Well, that is not the case in the United States. The big question here is, are there any limitations imposed by the DOJ? Is it something that's currently up in the air? So that if we do collect evidence that is discovered as a part of an arrest, can that same evidence be used for a different situation entirely?
Okay, I really appreciate the way you worded that because that was much clearer than was previous. I'm not, no offense, but that was very much more a litigator's question. Yes, is my answer. The evidence can be used, but I would implore you to use it wisely, because just because they are in possession of the weapon does not necessarily mean that you're going to prevail on the charges, right?
On the separate incident, right?
Right. So say it's a hot gun, which is kind of what was explained to me earlier. If they are found in possession of a hot gun, but there's no other evidence connecting them to that incident, or they have a solid alibi, you know, I would just implore investigation into those situations, you know?
Right. So you're talking about like, okay, I'd like to
I'm
deep
sorry.
dive.
Let me take this real
Yeah,
quick
go
and
for it.
then Yes, Johnny.
Chat, because we're talking,
I didn't tell them they had to.
you got to keep in mind, right, that you guys are chat, right? You haven't played on the server. You haven't dealt with cases. So there's little nuances to what I'm saying and he's saying that you may not pick up on. So for a listener, it may be like, isn't that the same thing? But it's not the same thing. Does that make sense?
Yeah, I'll be around.
Okay, so to dive
Sorry
into
about
that, if we could talk about particulars, are you suggesting, okay, so are you talking about, did this individual have the gun? Well, I mean, it would be constructive possession, right? And
right, so you could potentially charge them on that.
Right.
But if it's a weak case, I just implore you to use your better judgment, you know?
So, well, I agree with that 100%. But I want to make sure I'm not overreading what you're saying here. Okay, so let's go, I guess, to the other question. This would answer it is would that not require the defense to have wouldn't it require the defense to bring out a affirmative defense as to why said evidence did not belong to that individual at the time of the separate incident that is now up on the docket?
Oh, absolutely. That would be something that would be considered.
Okay. All right. All right.
If they're not going to make an argument to that, then that's no argument in the eyes of the court. We'd have to rule in favor of whoever has the most evidence.
Okay.
You know,
and what is
whoever meets the burden?
Absolutely. And I don't want to. I'm not going to like put you on the stake in the future for however you answer this. Is just for me to get a barometer check.
Right, and I don't expect. I hope you realize this is not going to be a blanket answer for every case.
Oh,
every case is
100%.
gonna be handled differently.
1,000%. The burden for affirmative defenses, in your eyes, where would you kind of place that in relation to, let's say, in California proper versus? You understand where what I'm trying to ask here?
I'd say it's a preponderance. You got to convince the court that there's a reason, especially if you're bringing, say, a cell trial to the court's attention. It's going to be a preponderance of evidence. If it's going to be if it's going to be a murder charge, like a court charge, that's going to be beyond a reasonable doubt. So
I got you.
In terms of
for the affirmative defense,
right? So it's going to be very close on those kinds of cases. If it's for an affirmative defense, though, on a murder charge, if it's like a hot gun connected to a murder, if they don't have an alibi, if they don't have any sort of affirmative defense, it's probably not going to go well for them.
Okay, that makes sense. Thank the fucking Lord.
It's really up to the narrative, right?
You know, a long time ago, there, Chief Justice, I had a 2-month investigation, 36 pages of cell phone text messages, call logs, GPS locations. And I was able to track down a series of explosions, ultimately leading to the invasion of a different island. And all because my best friend was blown up by a C4 in which a phone call was made at the moment of the C4 destruction. And there was no affirmative defense. And the guy got away. So,
well, I mean, that seems like a fairly complicated case, but
oh no, I had him.
Said, it seems fairly clear.
They had zero affirmative defense.
So
they just said, but cell phones.
He called the number that it set off the C4.
It just happened to be that this individual made phone calls at 3 separate, highly intensive detonation locations, just by happenstance, and by happenstance happened to be at the location where my best friend was exploded. But apparently that this judge said, you know what? It could have been somebody else.
Well, for a situation like that, which I imagine is terrorism, right?
Yeah.
It'd be beyond a reasonable doubt. So
thank the fucking Lord.
That compounded with other evidence would probably sway a court. If that was it, just the phone calls might not be enough.
Yeah. Okay. Well, shit. Oh no, there was significantly more. Trust me.
Well, then I don't want to give you an insight into exactly how I'm going to rule on certain situations, but I want you to know that we do appreciate, if someone's not going to even put up a fight against being accused of something, then that demonstrates that perhaps they are more guilty than not, especially if the evidence is conclusive.
Okay.
Does that help?
It does. So,
your fears a little bit.
Well, not so much of a fear. I'm not too worried with this DOJ. More the bar for the affirmative defense, and it sounds like it is a preponderance up to a beyond a reasonable doubt based on the gravity of the charges set forth.
Precisely. Yeah. If you're gonna bring someone to court for murder, I expect you to be beyond a reasonable doubt. If you're
Well, I'm asking about the affirmative defense, though.
Yeah, it definitely accounts in the judge's eyes.
I got you.
We
Okay.
take all of that into account.
Okay. Okay. Now I'm gonna ask a more complicated question. Is if we arrest somebody, they're found with a hot gun, comes back to a murder case, right? But they also have a note on them saying, I murdered Michael, the dead individual, right? And both the note and the gun are found in a store robbery, right? An arrest related to the store robbery. Does the note and the gun, both of those can be used for evidence for that separate case that would go up on the docket?
Yeah, if they were collected legally. I don't see
Okay.
why not?
Easy. And that includes if that arrest went through and we cataloged the evidence
the biggest
for that.
questions I ask in the bar exams is, what is the exclusionary rule?
Okay.
It's one of my big things is this evidence collected properly? So as long as it's collected properly, you know, it doesn't matter if it's in relation to the same incident. If you collected that and you find that it connects to something else, you can use that.
That is perfect. Okay, that very much answers the question. If you're curious, it's just, you know, like I said, previous precinct, it was kind of like, you know, you close the chapter once, not multiple times potentially.
I don't know
so-
that that's how policing works. I mean, a lot of people commit crime over a long stretch of time. So
Yeah.
in order to catch them, you might have to find multiple pieces of evidence until you
Okay.
get a real good. I mean, let's talk about racketeering. You know, RICO.
Mm.
It takes a long time to get that done. And a gang injunction, you got to prove a lot of stuff. It takes a few steps. So sometimes it takes more than just one incident. If we said you can't collect
By the way,
evidence
my statements
over a
here
long
are not
period
to
of time,
compare two servers,
that would
but
be
more to
wrong,
get clarity, right? This is interesting.
in my opinion.
Yeah.
I don't know.
All right. That is,
But you may also want to take this up with the commissioner. I mean, my opinion is that if you find evidence and it's legally collected, then that's fine to use.
yeah,
For the bigger case.
I agree. Obviously the governor and the Senate may feel otherwise down the line, but I generally believe that this makes for healthier cases, policing, and better for everybody. So I'm definitely all for it.
Yeah, I mean, as long as we're respecting the statute to an extent, you know, have a good argument for why it applies.
What is the statute here?
Typically, it's 14 days for anything that's below a court charge.
I see. And then what about court charges?
Unlimited.
Oh.
I
Okay.
mean, that could change depending on Senate and governor views, but
Yeah.
as far as I know, it's not changed. So
Okay, that is really good to hear. And when you say court charges, you mean charges specifically noted as out?
I mean, yeah, it's the big ones, right? So anything that's going to be years or
the ones that say court charge on it.
generally, yeah.
I gotcha. Okay,
Yeah,
that is
murders and
perfect.
terrorism.
So like terrorism, murder, manslaughter.
Wait,
fraud.
manslaughter, really?
I mean, manslaughter needs to be determined in a court of law because it can very easily turn from second-degree murder to manslaughter. in
Oh,
a matter of
understandable.
statements.
Bro, that is so good.
But
Okay.
that, fraud, corruption, even things that aren't necessarily in the penal code yet, but definitely should be. And I also implore people to use common sense, right? Like if something is a crime and we know it's a crime, I don't think we should be arresting people, but we should potentially try to push charges, take them to court, get those added to the penal code.
Absolutely agreed. Okay. Well, any other questions, Rain? I'm pretty satisfied.
Yep, no, I'm satisfied now too.
All right.
Yeah, I hope that was a helpful conversation.
Yeah, very much so.
Yeah,
This brings a
100%.
lot of clarity. All right.
And
We're just
honestly,
trying to get all our little ducks in a row.
Yep, exactly. We want to do more, you know, face-to-face. So small claims, traffic court. If we're around, bring it to us. We're happy to help.
Okay. That is perfect. All right.
Let's go for that 3.
All right. Well, thank you there, Chief Justice.
Yeah. Can someone help me down? I don't
Yep.
know.
Yeah, I'll just respond to this 311 minute.
All right. Oh my God, that is so fucking good. Oh my God. Ah. Oh my God. Brother, that just like is the best thing ever. We're not chasing 30 days for the big charges. But that also is good because it means hot gun is only 14 days, right?